All right. Hello and welcome to Learning the Law, a podcast about all things legal with a focus on current events, where we try to teach you things in an hour. My name is Ashley, aka Phoenix Nymphy, or you can call me General Leia tonight. My co-host, who is the man of the hour, my husband Ron, aka Han. This podcast is purely educational and should not be taken as legal advice. This podcast does not create an attorney-client relationship. This podcast is based on his interpretation of relevant law, and any opinions expressed are the opinions of the individuals making them and do not reflect the opinions of any firm, company, or other individuals. Ron is a licensed practicing attorney in the state of California.
I am, and have been since 1999.
I don't think you're actually using your microphone. It sounds very distant. Yeah. No, it's not. It's not actually on your microphone. That's why it keeps cutting out. Make sure.
1 second.
Yeah, let's try it. You know what? Live streaming. This is what happens when we're live.
Is that a double hood on that?
It is. Look at this. Look at this. I'm going to edit all of this out. This is, or I might not. I might just leave it in. I might leave it in. Anyway, we went to Disney this weekend and they had this in my size, and that is why I'm wearing this, because I am extremely happy that I have the Leia poncho, the Leia indoor poncho now in my possession. This is fantastic. Okay.
It even has a pocket.
It does. It does. Awesome. Okay, so we're not here. Our sponsor is not Disney this week. Our sponsor is it's NordVPN. With more than 10 years of experience, NordVPN is a leading VPN provider. NordVPN gives you military-grade protection online, and you can access all your favorite sites without restriction. NordVPN never logs your activity when using their servers. You can always trust your privacy to NordVPN. Thank you for sponsoring, affiliated, or for being an affiliate with Learning the Law. If you use our link that we have, which will be linked in all of the YouTube stuff, it's linked, should be linked everywhere. If you use that link, and we will get money from it. That's how this particular sponsorship works. They don't pay us outright. It's more of an affiliate link, but we appreciate it nonetheless. So, and NordVPN has been around for a very long time. It's a very viable source. So if you're here watching this podcast, hi, welcome. I look like a purple-haired General Leia today because, yes. So we're back from vacation. And oh boy, did a lot happen while we were on vacation.
Yeah.
Holy crap, so much happened while we were on vacation. So yeah, let's go. I mean, our vacation was nice. Not much to say other than we had a good time. We're back. Let's try and get through this podcast, though. We've got an hour to try to finish up Roe v. Wade, but we've got a lot of crap that is going on with Supreme Court news. So I'll let you take over.
Okay. As you recall, hopefully, when we last discussed this, we
do you not want to go over the Supreme Court stuff that has come out over the last 2 weeks, or do you want to do Roe v. Wade first?
Let's do it first and then end it with the arguments.
The updates? Okay.
Yeah.
Okay. All right, cool.
Okay. They're trying to balance the interest of the woman versus the interest of the fetus.
Yes.
Okay. And so when we go to paragraph 76, you find them now starting to talk about the right of privacy. And they will come out and say the Constitution does not explicitly mention any right of privacy. However, they then go through a line of decisions going back to the first one, the Union Pacific Railroad versus Bedford, 1891. And the court has recognized that a right of personal privacy or a guarantee of certain zones of privacy does exist under the Constitution.
Meaning,
there is an implied right of privacy in the Constitution, even though it doesn't explicitly say it.
And that is a precedent set over 100 years ago.
Yes.
Okay.
And so this right of privacy, whether it's founded in the 14th Amendment to the Constitution and the concept of personal liberty and restrictions on state actions, or the 9th Amendment, reservation of rights to the people, right here in paragraph 77, they say is broad enough to encompass a woman's decision whether or not to terminate her pregnancy.
Oh, geez. Thanks for including us in this, I guess.
The detriment that the state would impose upon a pregnant woman by denying this choice altogether is apparent. Specific and direct harm, medically diagnosable even in early pregnancy, may be involved. Maternity or additional offspring may force upon the woman a distressful life in future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There's also the distress for all concerned associated with the unwanted child. And there's the problem of bringing a child into a family already unable, psychologically and otherwise, to care for it.
Funny how that's literally all I've been saying this entire miniseries.
Yeah.
There's so many more factors that go into this. It's not a, just like with anything, it's not a black and white situation. There are so many things that go into making any kind of decision like this. And no, it's not, it is technically a form of birth control, but it's not being used so blatantly like that. It's more than just, oh, I opened my legs up and got pregnant. Whoops. No. And so many people think that way. The far right GOP thinks that way. And that's not at all why people have abortions. I mean, I had to block a few people on TikTok this last week because of their just blatant racism and white supremacist support for Roe v. Wade, because it's literally a way to control the population. And guess what? Adoption agencies have
Yeah.
I'm going to hold off on this until the end because it has to do with the Supreme Court justice. But I will say this. A lot of adoption agencies have closed down due to the fact that there aren't as many children to be adopted out. And the foster care system is so broken. It needs to be fixed. Like, it is another system that is really screwed up. However, since, the statistics over the last, 50, 60 years show that there's been a decline in abortions and a decline in the amount of children being adopted out, which is a good thing. It is a good thing to not have children in adoption agencies, because that means they are in a home, not in an unstable environment. And so I just take that into account. That is a good thing. Well, the GOP is all about the baby.
Oh, I know. Well, the GOP is also about restricting contraception, too.
Yes. And it's like, wait, what? You want to restrict contraception. You also want to force me to have the baby, but you don't want to help me have the baby and take care of the baby.
Right. They're pro. Well, I shouldn't get into my opinion.
No.
Anyhow, so the next paragraph 78, the Supreme Court goes on to say, on the basis of elements such as these, some appellants and amici, which remember are friends of the court, they submit their own brief.
Yes.
argued that the woman's right is absolute and that she is entitled to terminate her pregnancy at whatever time, in whatever way, and for whatever reason she chooses. With this, we do not agree.
So the Supreme Court does not, even at that time, did not agree that a woman had a right to her own body.
Correct.
Interesting.
They would not agree that an abortion after 8.5 months would be a right of the woman to have.
Oh, I see what you're saying. They're not necessarily saying we don't agree, but no, they are. They are absolutely saying a woman doesn't have the right to her own bodily autonomy, and they're still putting constrictions on that, even though they're like, yeah, you have a right to choose up until this point, but it's like,
right,
you're still, that means you don't actually believe that I have the right to choose.
Because they're balancing the interest as they see them.
Yes. Which legally I understand. Yes. Like this is the compromise that was created.
Yes. Okay. And so they say this, we do not agree. Arguments that Texas either has no valid interest at all in regulating the abortion decision or no interest strong enough to support any limitation are unpersuasive. The court's decision recognizing a right of privacy also acknowledged that some state regulations in areas protected by that right is appropriate. As noted above, a state may properly assert important interest in safeguarding health, in maintaining medical standards, and in protecting potential life. At some point in pregnancy, these respective interests become sufficiently compelling to sustain regulation of factors that govern the abortion decision. The privacy right involved, therefore, cannot be said to be absolute. In fact, it is not clear to us that the claim asserted by some amici that one has an unlimited right to do with one's body as one pleases bears a close relationship to the right of privacy previously articulated in the court decisions. The court has refused to recognize an unlimited right of this kind in the past. They go back with Jacobson v. Massachusetts.
The vaccination case. Yes, right. Because that's different though, because, okay, I'm going to argue that that's different because a vaccine, like a cold, a sickness, an illness that is contagious. Pregnancy is not.
Pregnancy is not contagious. However, if you have an interest in the fetus at some point.
You mean the parasite that's living in someone's body until it's a viable child?
Well, there you go. The court has already said that that entity has an interest in life at a certain point.
So what's the sterilization case here in 1927? I'm actually curious. Buck versus Bell?
I did not look that up.
Okay.
But I'm going to say that there is probably a forced sterilization.
Yes, because that is something that we still practice. In fact, did you know that up until 2014, California was practicing forced sterilization of prisoners?
I'm not surprised.
They banned it in 2014. They passed a law banning that in 2014. It's still a practice in this country. And I learned that recently because my best friend reminded me about this. And so I started doing some research and I did a couple of TikToks on it. And I kind of want to talk a little bit more about that on TikTok and make that a series because
I have a nutshell of Buck v. Bell.
Okay.
1927, the U.S. Supreme Court set a legal precedent that states may sterilize inmates of public institutions. The court argued that imbecility, epilepsy, and feeble-mindedness are hereditary, and that inmates should be prevented from passing these defects to the next generation.
That is the argument for forced sterilization. Yeah.
Yeah. Okay. So they said that's perfectly fine for the states to do that. I haven't seen if that was ever overturned, but
In the state of California, it's overturned because that was how it was worded. So they used that as a reason to say women don't have full autonomy over their bodies, which to me is kind of messed up because forcing sterilization is screwed up. Forcing someone to have their tubes tied or get snipped or any number of things is so messed up. Wow. Okay.
okay. So after this, they say, we therefore conclude that the right of personal privacy includes the abortion decision, but this right is not unqualified and must be considered against important state interests and regulation.
Meaning
that there is a right of privacy. It includes abortion decision and in other cases, medical decisions, but that it's not an unlimited right.
I do disagree with that, but okay.
So states can regulate it. For example, needs to be done in a medical clinic. Can't be done in your home.
That I respect. Yes, it should be an ethical abortion done by a professional who knows what they're doing in a hygienic, clean environment.
Right. So when they say that a woman's not entitled to terminate her pregnancy at whatever time, in whatever way, and for whatever reason, includes things like that.
Gotcha. So see, I mean, even Roe v. Wade is not perfect.
Oh, God, no.
Okay.
Okay, then it goes on saying that there have been federal and state courts that have considered abortion law challenges and have reached the same conclusion that the Supreme Court is reaching right now. And that some bans have been held unconstitutional, at least in part because they were vague or overbroad.
Okay.
And then they give a list of cases.
So these are talking about kind of like the Texas abortion law right now. It's too vague and
okay, it's not only vague, it's vague and overbroad.
Yeah,
it's both.
So Roe v. Wade, absolutely, like if that law existed then, would have said no. Go, it's got to go.
Right. Yeah. So then they go on. They're given some more discussion. It says, when certain fundamental rights are involved, the court has held that regulation limiting these rights may be justified only by a compelling state interest.
Okay. What do they mean by what is a compelling state interest?
A compelling state interest, and this is an interest that is so important that there's no other way of upholding that interest.
Oh, you mean like
to a legitimate state interest where, the state interest
so a compelling state interest is like a vaccine mandate or a mask mandate. It's to help everyone in the state.
Yeah.
Okay. A pregnancy should not be listed under a compelling state interest, though.
That the compelling state interest is not the pregnancy.
It is
the compelling state interest is the potential life of the fetus.
What? Okay. How?
How? Well, the state has an interest in having citizens
Okay, the
having them pay
state has an
taxes.
okay, I get that, but you don't okay. But that child isn't going to pay taxes and in fact is going to utilize so many resources before they're even able to be a part of society for 18 years. So that's
Correct.
kind of a stupid argument to me.
Well,
Because
you
it's
gotta
going to
get your taxpayers from somewhere. Right?
okay. So the compelling, it's literally a financial thing. That's the compelling state interest. It's a capitalist.
Everything comes down to money.
It's bullshit. Okay. So there's no actual compelling state interest. We can move along now. We've established that.
Well, the Supreme Court said that there is, and they're trying to balance it all out.
But there's not. But okay, continuing.
Okay.
There's not.
Okay.
There's not. Aside, take the money away. If we lived in a society that we didn't use money, okay, we don't use money. It's just a barter system. It wouldn't. Nobody would care about the abortion thing because they would know that that baby is not going to do anything to benefit them in the long run until they become an adult. So it's like, okay, do whatever you want to do. Be honest. If we did not have a money system and we didn't live in a capitalist society, nobody would care as much as they do about this.
As much as they do, that's true. Some people still would care an awful lot.
Well, that's because they're the religious zealots. There's always going to be that. But
Well,
nobody, this would not be as big of an issue as it is right now.
Currently, you have religious zealots controlling one of the two parties of this nation.
Right. So it just, yeah. I don't think the religious zealots would be in power if we didn't have a capitalist society. Personally, but
those that strike down these state laws have generally scrutinized the state's interest in protecting health and potential life and have concluded that neither of those interests justified broad limitations.
okay. I'm a little distracted by the dog. Okay, explain that to me again.
Okay. The state laws that have been found unconstitutional are too broad.
Okay.
The interest in protecting the mother's health and the potential life of the fetus are not compelling enough.
Okay, so basically they're calling out the state saying, this isn't quite compelling enough as you think it is.
Right. Now,
Okay.
the courts that have sustained state laws have held that the state's determination to protect health or prenatal life are dominant and constitutionally justifiable. So you got some courts in the state ruling one way, some courts in the state ruling another way, which is another reason this goes up to the Supreme Court.
Right. Okay. I need a haircut. My hair has gotten so long. It's so long.
Then we get to paragraph 86, where it says the appellee and certain amici argue that a fetus is a person within language and meaning of the 14th Amendment. In support of this, they outline at detail and at length the well-known facts of fetal development. If this suggestion of personhood is established, the appellant's case, of course, collapses, for the fetus's right to life would then be guaranteed specifically by the amendment.
Okay.
And Roe conceded as much on re-argument, that would be the case if it's a person under the 14th Amendment.
Yes. And what is the 14th Amendment again?
You want me to read it off?
Is protection which figures prominently in wide variety, blah, 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 blah. It's just all persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Okay, I see now. All right. But the thing is, okay, so basically it's the argument of when does life start?
Right.
Is it at conception or first breath? Scientifically,
or somewhere in between.
Yeah.
Liability.
Yeah. Okay. All right.
Okay.
So that's okay.
You were about to say something. I cut you off. I'm sorry.
No. Go ahead. Okay.
So in 87, they say, the Constitution does not define person in so many words. The 14th Amendment contains 3 references to person.
Right. Which I just read.
Right. Person is used in other places in the Constitution. But in nearly all of these instances, the use of the word is such that its application is only natally.
Yes.
Which means after birth.
Because it's meant, it's describing people who can actually give back to society, not a fetus, which does nothing for society when it's in the womb.
So, okay. And right. And they say then that throughout the major portion of the 19th century, prevailing legal abortion practices were far freer than they are today.
Oh, yeah.
This persuades us that the word person, as used in the 14th Amendment, does not include the unborn.
Okay.
So there you go. The unborn are not a person within meaning of the Constitution.
It is potential personhood. It is potential life.
Right. And they say that this conclusion does not in and of itself answer all the contentions raised by the state of Texas, but we pass on those other considerations.
Yeah.
They're not going to address them.
They're just like, meh, we're not going down that rabbit hole.
Yeah.
Why is it always Texas that is trying to enforce the strictest laws on women and people of color?
Well, I have my thoughts, but it's not appropriate for this particular.
I just feel like Texas seems to be the one always leading the way in this kind of stuff. And that's not saying other states don't do that. They absolutely do. But it always seems to be a Texas law that ends up making it to the Supreme Court.
Yeah.
Texas is also the reason why you cannot secede and why they made sure to put that in. I don't remember which amendment it is, but like it's now virtually impossible for a state to properly secede from the union.
Can't. We had a whole war over it.
Well, I know, but Texas, they had to make sure that it was difficult because Texas was like, well, we're not, because even after the Civil War, Texas was like, we're not staying. We're going to stay our own country. Remember?
Because Texas was a country before it was a state.
So it's always Texas.
And, they basically stole that land from Mexico.
Yep. Yeah, it was a country. It was Mexico.
It was Mexico. Mexico invited a lot of immigrants to settle that land because it was sparsely populated and needed, farmland and stuff.
Yeah.
A bunch of Americans came and took over Texas. They decided they didn't like the Mexican laws, and all of a sudden you had that war in the 1830s and Texas became its own nation.
Yep. Anyway, moving along.
Okay, so they then go on to say that a pregnant woman cannot be isolated in her privacy. She carries an embryo and later a fetus, if one accepts the medical definitions of the developing young in the human uterus. So they will use those terms, embryo and fetus. The situation is inherently different than marital intimacy or bedroom obsession of missing material or marriage or procreation or education, which it was with Einstein and Griswold. And they're talking about other cases there
Yeah.
where you had a right to privacy as far as keeping pornography, whether or not you're married, contraception,
Yeah.
that kind of thing.
Loving. Is that the same loving that I'm
Yes.
thinking of? Okay. The interracial marriage. Yes.
And I will say, when they say interracial, they didn't have a problem with veterans coming back with Asian quote war brides.
It's just
It was specifically
black
and white.
Yeah, black people and white people getting married specifically because this country's racist.
As we have intimated above, it is reasonable and appropriate for a state to decide that at some point in time, another interest, that of health of the mother or that of potential human life, becomes significantly involved. The woman's privacy is no longer sole, as SOLE, not SULOUL. You know,
SOUL, you mean?
Yeah, that's
Like-
exactly. Or SOL, like the sun. And any right of privacy she possesses must be measured accordingly.
It means she is no longer one entire person. They're saying that she becomes two.
Correct.
So, and you know what I find very interesting is if you look at it and so we were all children at some point in our lives, right? And I've said this before, we did not choose to be born. So if we are aborted, we're not going to know. It doesn't the only argument, that they say that they use is not even, I don't even think they fully believe that it's my thought process is, I was about to say, even as former babies, we all still believe in abortion. Like, even as former babies, former fetuses, because we were all former fetuses. So, I don't know, this argument to me just seems really stupid. Because I feel like the primary body is the one that makes the decisions, which is the mother. Like, a baby's brain your brain isn't even fully formed until you're in your 20s. Did you know that? Your brain is still forming, and that's why most people aren't diagnosed until their 30s with mental health, because your brain is still developing.
Right.
Into your 20s. So anyway,
Texas urges, this is paragraph 91. Texas urges that life begins at conception and is present throughout pregnancy, and that therefore the state has a compelling interest in protecting that life from and after conception. This court then says we need not resolve the difficult question of when life begins. When those trained in respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer.
Which I respect. I do respect that, because absolutely correct. You don't have a consensus on that. Even though the religious zealots seem to like to gloss over that Jesus literally says life begins at first breath, but
Right. And the next paragraph 92 goes into a short nutshell of different beliefs of when life begins.
Yeah.
Um,
Yeah. Jewish Christian faith, it's actually supposed to be that, like, I mean, life at first breath. It's not at conception. And a lot of the problem with, like, in Christianity, they use it's like in Psalms, I formed you in the womb. But the thing is, it's a metaphor. It's not like, those are the people that take the Bible literally. And it blows my mind, the amount of people who take this book that's been, that's thousands of years old. Literally, like it's a history book is what it is. It's a history book, and it's not even 100% accurate. But it's like, it's a history book. It's a book of virtues. You learn from it. It's not meant for you to pull your current laws from it. And society has changed since then, and as society evolves, and that's why it is so vague. It's meant for you to be able to evolve and grow. And it blows my mind how rigid.
At the end of paragraph 92, when they talk about life begins at conception, they say that one amicus brief has this view, but there are substantial problems for precise definition of this view by new embryological data that purport to indicate that conception is a process over time rather than an event, and by new medical techniques such as menstrual extraction, the morning after pill, implantation of embryos, artificial insemination, and even an artificial womb changes how life begins at quote unquote conception.
And the thing about conception is, it's not a one-day event. Like, it's not boom, it's like a 2-week process for the egg to actually be, like, it's an entire, like, it is a long process. It's not, egg, sperm, you're pregnant. No, like, just because the sperm gets to the egg still has to attach to the uterus. Like, it's a long process.
Right. And then in paragraph 93, they go on and they say, in areas other than criminal abortion, the law has been reluctant to endorse any theory that life as we recognize it begins before live birth, except in narrowly ruled defined situations. For example, traditional rule of tort law, which is, personal injury kind of stuff, denied recovery for prenatal injuries, even though the child was born alive.
I'm so confused.
For example, say you're pregnant, I punch you in the abdomen. They prove that the child is now mentally disabled because of what I did. Well, you weren't able to sue for that.
I'm sorry? No.
You were not able to sue for that because the kid was not alive at the time.
Oh, okay. So they're saying that because there are some things that are outside the womb that can cause defects like that. Okay.
Right. And then they're saying in most states, it has been changed over the years to have some kind of recovery if the fetus was viable or at least had quickened when the injuries were sustained.
Okay.
Similarly, unborn children have been recognized as acquiring rights or interests by way of inheritance or other devolution of property and have been represented by guardians ad litem. So, for example, You can put an unborn child in a will or a trust. You can say my future children or my child in utero.
Mm-hmm.
You know, they let that in the law as well.
Yeah, and that's with people who want the child.
Yeah. Nevertheless, they say the unborn have never been recognized in the law as persons in the whole sense. Hence why you don't get a tax deduction for being pregnant.
So if they do overturn Roe v. Wade, then we should be getting tax deductions for having a child in utero.
If they're going to consider that the unborn child as a person, yeah, you should.
If they overturn Roe v. Wade, I would absolutely claim pregnant. I'd be like, yeah, I got a dependent. She's not born yet, but y'all say she's a person. So there you go.
And if the IRS challenged that, you would not only have this case overruling Roe, you could also throw in your religious belief. So then in 94, the Supreme Court says, in view of all of this, which they've said time and all that, we do not agree that by adopting one theory of life, Texas may override the rights of a pregnant woman that are at stake. We repeat, however, the state does have an important and legitimate interest in preserving and protecting the health of the pregnant woman, whether she be a resident of the state or a non-resident who seeks medical treatment in the state. With respect to the state's important and legitimate interest in the health of the mother, the compelling point, in light of present medical knowledge, is that at approximately the end of the first trimester, this is because of the now established medical fact referred to above, that until the end of the first trimester, mortality in abortion may be less than mortality in normal childbirth. Do you understand that?
Yep.
Okay.
Basically, it's talking about the viability of if you were to have a child at 12 weeks, it's not going to survive.
It's not going to survive. Also, it is a mother having a first trimester abortion has a better chance of living than someone who takes that pregnancy full term and has childbirth.
Yeah, because the mortality rate of women is still extremely high in childbirth. More in women of color than white women. This is factual. In fact, I read an article earlier today that was talking about a mom who just had twins, and they were early. It's very common for twins to be born early. And
yeah, because there's no room for them.
Yeah, it's very early for twins to be it's very common for twins to be premature. And so, and a lot of, she had them very early. It was about the same time that Yvette's twins were born, like that, where you don't know if the babies are still going to survive. It was very early. It was like 28 weeks or something like that. It was still very early. Which they can survive at that, but it's still on that line. It's still on that risk. And her doctor was a Black woman, and her gynecologist was a Black woman. And the article was talking about how we need more Black gynecologists and Black doctors because the mortality rate goes down when you have those Black doctors, because the infant mortality rate is very high, and the mother's mortality rate is very high in Black births. I mean, it's just I don't have the numbers off the top of my head, but I mean it's studied, it's shown, it is a legitimate thing. A simple Google search will find it. So it's
You'll also find that the mortality rate of women in general in the U.S. is very low for an industrialized.
You mean very high?
I'm sorry. Yeah, it's very high for an industrialized nation.
For an industrialized nation, we have more women that die in childbirth and more children that die in childbirth than any other industrialized nation.
I don't think we're in the top 20 as far as low mortality.
Yeah, it's still very much a problem, which is another reason why I think that Roe v. Wade needs to stay, because like it's just another notch on the thing, just to show how much we're not in on these conversations and discussions.
Right. So they're talking about then, this compelling point is at the end of the first trimester. Right?
Yeah.
So they say that this means that for the period of pregnancy prior to this compelling point, the attending physician, in consultation with his patient, is free to determine without regulation by the state that in his medical judgment, the patient's pregnancy should be terminated. If that decision is reached, the judgment may be effectuated by an abortion free of interference by the state.
So basically saying, if the doctor says, yes, let's do this, the state can't say anything.
With the patient in consultation. The doctor just can't say, oh, you need an abortion and I'm going to do it now.
No. If the patient is like, hey, I want an abortion, and the doctor's like, yes, or the doctor suggests this is not going to be a viable pregnancy, I would recommend you have an abortion. And yeah.
Okay. So then,
with the patient's consent, the patient, and that is very important, because forced abortions are a thing in this country, especially amongst women of color.
Then in paragraph 97, you have, with respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus then presumably has the capability of meaningful life outside the mother's womb. State regulation protective of fetal life after viability thus has both logical and biological justifications. If the state is interested in protecting fetal life after viability, it may go so far as to prescribe abortion during that period, which,
Proscribe, not prescribe.
I said proscribe.
Yes, but it sounded like you said prescribe, which is, the O was very
Oh, sorry.
So what does proscribe mean?
They can ban the abortion.
Okay.
That period, except when it is necessary to preserve the life or health of the mother.
Okay. And the current Texas abortion ban goes against all of this, by the way. The Texas Abortion Act they don't care about the health of the mother.
Correct.
There is no excuse. You cannot have it. That's the Texas abortion law.
Correct. After 6 weeks.
We have a mini series of that. You can go back and watch. That's an earlier series. Highly recommend go back and listening to that, where we go in depth over the Texas abortion law and read the whole thing and discuss it.
Okay. Right. Paragraph 98. Excuse me. They then say, measured against these standards, 1196 of the Texas Penal Code, and restricting legal abortions to those procured or attempted by medical advice for the purpose of saving the life of the mother, sweeps too broadly. The statute makes no distinction between abortions performed early in pregnancy and those performed later, and it limits to a single reason, saving the life's mother. the legal justification for the procedure. The statute, therefore, cannot survive the constitutional attack made upon it here. So they just said it's unconstitutional. And
Yeah.
therefore, this conclusion makes it unnecessary for us to consider the additional challenge to the Texas statute asserted on the grounds of vagueness.
Yeah.
And then paragraphs 100 to 106.
It's a summary.
Summarize and repeat.
Yeah.
And there you have it. That is Roe v. Wade, and how you get your trimester guidelines as to when you can and cannot regulate abortion.
So the title of this series, I have to go to the bathroom really quick. So we're going to take a short break and then we'll come back and kind of wrap up because we are getting towards the end. We'll be a little bit longer than an hour this time around. But we'll come back and summarize and catch up on what's happened the last couple of days, last couple of weeks. Let me go to the bathroom. We'll be right back. The title of this series has been Roe v. Wade, not just about abortions. I know. Okay. So, and the reason why it's titled that way, even though it is, the whole thing is mostly about abortion. It's about your right to privacy. So
Right.
in over,
You'll see
sorry.
in all their analysis, it's the right to privacy that encompasses your fundamental right to have an abortion.
Right. Which means it is your right to privacy. And if I am not mistaken, Roe v. Wade is used for a lot of privacy precedent.
It was. Yeah.
So if Roe v. Wade is going to be overturned, which I know right now it looks like that is what's going to happen, that's not necessary. It's not necessarily going to happen. They have heard arguments on Roe v. Wade, and now they are going back and forth, they're discussing it. And yeah.
You're talking about the Missouri case.
Yes, they have discussed the Missouri case.
Okay. We'll talk about that in just a second.
Okay, yeah.
We'll segue into it. Okay, so they've based it on the right to privacy, especially in medical privacy. You can't get rid of Roe v. Wade without getting rid of that line of analysis and logic.
Right.
So if you don't have that right to privacy anymore, your medical information can potentially be opened up to a variety of people that are interested in it, because you don't have a right to the privacy there, except for HIPAA. If HIPAA wasn't a law,
right,
then you could be problems, and maybe HIPAA would at some point be overruled or legislated out.
Especially if they keep a law like the Texas abortion law on the books. It could definitely lead to. So it's Mississippi, by the way, not Missouri. It's Mississippi.
And I'll tell you why this is important. Insurance companies would love to have the right to your DNA profile to see if you are genetically
predisposed
to certain genetic conditions.
Cancer is one. I mean, cancer, Parkinson's, Alzheimer's. There are
so now.
Yeah.
As a baby, you have a pre-existing condition, and I'm not going to give you any insurance for the rest of your life.
Yeah.
That's
and
one of the aspects of overturning this,
which is huge.
No one talks about it.
No, it doesn't. And I really want to emphasize that it also opens the door for your privacy everywhere else. It opens the door for, it's not just a health privacy thing. It's also privacy in your own home, what you do in your own home with your spouse. It opens that door. I mean, we just discussed earlier.
Not just your spouse.
Yeah, what you do with your significant other or any person, any person. It opens the door to what you do in your bedroom. And I say that loosely because, not everybody has sex in the bedroom. But what you do in your private time, it opens the door for that and allows officers who already are overreaching to be able to come into your house. You could potentially have officers coming into, or looking, I think in the 60s, people like gay rights will get overturned because sodomy was illegal for the longest time. And
Bowers v. Hardwick, the Georgia case.
Yes.
20-year sentence.
Yeah. With their own partner in the privacy of their own home, because someone could see through their front door because someone could see through the window.
Right.
Even though you have a right to privacy established in Roe v. Wade to do what you want to do, established in Roe v. Wade and other cases like Loving and all of the others that were named. In overturning Roe v. Wade, it opens the to overturn LGBT rights and contraception rights. It opens the door to overturn civil rights.
I think that is ultimately what the GOP wants.
Oh, absolutely. And overturn this is why Roe is so pivotal right now. In overturning Roe v. Wade, it opens the door to overturn and set us back literally 60 years. Because remember, the right for a Black person to go to school with a white person was only 60 years ago.
Right.
That's it. My parents remember when their schools were desegregated. This is why Roe v. Wade is so important. It also opens the door to taking any rights away, that the very few rights that women already have, it takes all of that away. It overturns all of that. This is why Roe v. Wade is important and why it needs to be upheld. It's not just about abortion.
And so we now come to the Mississippi law. Right?
Yep.
Where they want to ban abortions after 15 weeks.
Yes. Which previously, in the discussion of this, 16 weeks was the cutoff in previous times, and they expanded it in Roe v. Wade to 21, I think.
Viability was 24.
24. Viability is 24. So
as we just saw in the holding of Roe v. Wade, it's the first trimester that the state cannot interfere with.
Yes.
So the first trimester, since a woman's pregnancy is, human pregnancy is 39 weeks.
Between 36 and 39 weeks, yes.
The first trimester is considered weeks 1 through 13.
Yep.
So this Mississippi law is week 15. And it's
which is
in the second trimester.
It's 2 weeks into the second trimester, which, correct. Fun fact, a lot of miscarriages happen that first month of the second trimester.
Right. So,
I mean, they happen throughout the second trimester.
Overturn Roe v. Wade.
Does it really overturn Roe v. Wade?
It does not.
No, it doesn't. The Texas abortion law does.
Texas abortion law does. So what you have But you have all this media saying, oh, they're going to overturn Roe v. Wade. They're not overturning Roe v. Wade if they find this, because it's a second trimester law.
Technically, yes. The problem is
what they are doing is overturning KCV Planned Parenthood,
yes,
which was a later abortion case by the Supreme Court in 92, where they found that an undue burden in obtaining an abortion interfered with your fundamental right.
Yes.
That may be overturned.
Which is also extremely important, because it will be more than just abortion that it will affect. It will be any medical procedure that a woman tries to take.
Yeah. So when they say that they're going to overturn Roe v. Wade, technically they're not.
Not with this case, no.
No, not with this case. It's another little chip away at it.
Yes. Just like the way they are chipping away at the Civil Rights Act of 1965. 65?
64.
64. Yeah.
It was the Voting Rights Act of 65 that they're chipping away at as well.
Yes.
Because eventually they want to bring back separate but equal.
Yes, which is not in any way plausible.
You know, the black versus white water fountains again.
Yeah.
You know, you can't have a black person at a lunch counter with whites. All that BS. That's when, and now we're getting into my opinion, that's when all these people thought America was great. And that's why they want to make America great again.
Yeah. Because they did not have to deal with other talented people coming in and taking over anything. It's why the Tulsa Race Massacre happened. It's why mediocre white men and women, because white women are guilty for upholding white supremacy, even though we are oppressed under a white patriarchy. We are upholding the white supremacist, the white supremacy system that exists right now, because it allows us to not have to do anything. So we're coasting, but we're still oppressed. White women are oppressed. It's just stupid white women continue to uphold the current system when they could benefit from a changed system themselves. And so when it comes to the level of oppression, when it comes to women, and I saw this, a TikToker described this, and I forget her name, and she did a wonderful job, and I appreciate what she did in visualizing it. When it comes to oppression, you have she's teaching intersectionality and why intersectionality is important when it comes to these kind of things. You have white men, right, up here, white cis men up here, and then everybody else is below it. And women are here together. But when it comes to certain things, when you add on a woman of color, her oppression goes a little bit lower, a little bit lower, and a little bit lower. But we still have the same issues that we want to work on to get here, so we're equal with these guys. And same thing if you take black women and black men, you've got them on the same level as black people, but then the women are down here just a little bit because they're treated lesser than, because these guys are male, right? So that's why intersectionality is so important, and why it is, it's okay to, you need to also, if you support women's rights, you need to support women of color's rights. You need to support the LGBT community, because we're all more than just one thing. I'm more than just a woman. I'm more than just a white woman. I'm a white queer woman, right? A black woman is more than just a black woman. She is, possibly a black queer woman, possibly, all of these things. So, possibly a Black trans queer woman, right? Like, so we are more than just these things, which is why intersectionality matters and why it is important for us and for the people who actually care about other people to help each other out. Which is why I'm constantly harping on women of color, because I am at a position where I realize that I still benefit from the system. And because I do have a little bit of privilege, I have that ability to help uplift these women to my space so we can help each other uplift to where Ron sits, right? I wish I could remember the TikToker's name. She's fantastic. But it was just a one-off. I'd never seen her before, but it definitely resonated with me. And so this is why this is important to not have it chipped away at and overturned. Because
as a side note, that's how Brown v. Board of Education was upheld by the Supreme Court. There was a process where they were able to chip away at these racist segregationist laws.
mm-hmm.
They started at the local level. There was a great HBO movie about this maybe 10 or 20 years ago. And they eventually got all the way to the Supreme Court.
Is it the one called Brown versus Board of Education?
Well,
isn't there
probably
isn't there
probably be an appropriate title?
I mean, isn't that what it was titled?
Yeah, that's the title of the case.
Right, but I mean,
I don't know if that was the movie title. It probably was. But that just
was it in the 90s?
Yeah, I think it was.
Separate but Equal is the name of it.
Oh, okay. And they just chipped away and chipped away. And it took them
Sidney Poitier. Oh.
It took them decades. I don't recall Sidney Poitier being in this one, but okay.
Sidney
But yeah.
Poitier as he played Thurgood Marshall.
Oh, okay. You've got to be patient when you have a plan in the legal field.
And that it sounds like that's exactly what they're trying to do on the GOP side. It is
correct.
And it's absolutely a long game because they know that they are losing power. And if they don't chip away at this stuff, they will lose power. The average age of Congress is like 60s. So these are people who were kids during the civil rights movement wanting to go back to what it was, meaning they're racist white men.
Well, not only that, look at the average personal value of each person in Congress, and I doubt you'll see anyone below $1 million.
Right.
Not only are they white men, generally speaking, they are rich white men.
And I stand Bernie Sanders, I do, but he's an old white dude too. I would rather have more AOC people up in there, more people my age and close, like I want to see myself represented up there. And if I want to see myself represented up there, I know other people want to see themselves. I don't feel represented in Congress. I don't.
You're not. But like I said, it's the long game.
Yeah.
If Bernie's the only one right now that is popular enough to try and get some of these things done, then you got to go with Bernie.
The problem is the Democratic National Committee doesn't think that way because the Democrats have bad leadership. They have nice ideals, but they have no leader.
The problem with the Democrats, and I've told this to my friend Scott, is that they are not a solid block like the GOP is. They won't come and agree with each other.
Right. Manchin.
And therefore nothing gets done.
Mm-hmm.
And unfortunately, the population then sees them as being weak and out of touch and a bunch of idiots.
Yeah.
And we'll probably see that in the midterms of 2022.
Which is, please vote next year, but please vote Democrat. Otherwise, it's just going to make it even more like. So, on top of the fact that the Supreme Court has heard the Mississippi case, there was also a Supreme Court study that Biden asked for because he didn't know yay or nay on whether or not he wanted to expand, the Supreme Court.
He was against it initially.
He was, but he did promise that he would do a study on it. So the study traces the history of, this just came out actually today. So they have now sent the report to Biden, and hopefully he will do something because it is not equal. The Supreme Court is not equal, and it doesn't actually represent this country. And I think that's messed up because I love when people from the Republican side argue that most people think this way. When you look at all the statistics, it shows 60% of Americans are actually leftist. They're left of center. They're not full on Democrat or most of it, but we are left of center, not right of center. But the Supreme Court does not reflect that. So it is a purely it should reflect the majority of our people, and it doesn't. And that is how you keep power when you are the minority. So the study traces the history of the court reform debate and delineates arguments for and against various proposals, occasionally noting areas of bipartisan support, as in the case of imposing term limits on the justices. So there's a lot in this. So I'm hoping that he will come to a decision and at least add some more Supreme Court justices, because when I was a kid, there was more than what we have now.
There's 9.
When I was a kid, there was 9. I thought there was 11 when I was a kid.
There have been 11 in the past. There have been as few as 7.
Okay.
But since I've been alive, it's been 9.
Oh, really? Okay. All right. Maybe I just remember learning there was 11 at one point when I was a kid. Because I remember I was fascinated by the whole Supreme Court justice. Man, I am just processing this. I'm just realizing this. I've always been kind of obsessed with law and order when I was a kid, like the justice system. Did you know that sound is actually trademarked?
No, I did not.
I learned that recently. Fun fact. The dun-dun.
Good thing I didn't make the actual sound.
The dun-dun for Law and Order is trademarked. So anyway, so this article came out today, and so that's, again, more stuff on the Supreme Court. Like, we could potentially see the Supreme Court expanded again. It has been 11 in the past. But one thing that I really wanted to note, and I will refer back, Amy Coney Barrett has, which she was, which we all knew this before, like she's very open about her opinion on abortion and stuff. Well, like she actually has money and funding in adoption agencies and makes money from adoption agencies. But when there's no kids to adopt, her and other people like her don't make money. So I think that's really effed up.
They should have made her get rid of
and she still has those ties.
Her money ties.
she still has those money ties, which is the very most disturbing thing about that. So
they're never going to do that now. They never made Trump get rid of his stuff.
no,
Yeah,
Trump should have.
They made Jimmy Carter sell his peanut farm.
But they didn't. Yeah. So they allowed Trump to keep his towers and other weird things. So anyway, suffice it to say, I don't think anything that Amy Coney Barrett actually comes up with is worth a grain of salt, because all of her stuff is going to be based off of what she's going to make, how she's going to make it. You can't tell me that's not how she's going to think, because she's trying to run a business. Well, business is bad right now because children are not being born, because mothers are allowed, people who birthers are allowed to make decisions about their own bodies right now, currently. So that is something that I think is very messed up. And I don't think she should have ever, her and Kavanaugh both should have never become Supreme Court justices, because if you have a history of sexual assault, you should not, even if it's not proven, just having that allegation for multiple people, no, that's a no. But I will end, my opinion right now is ended. I will stop talking now.
Okay.
I could keep going on and on for this, but there's no point. It's based off of this knowledge that we have, and yet we allowed these people to still go through because we're not actually represented in Congress. And a lot of this kind of stuff makes me want to go run for office so bad, because I'm so... Yeah. Also, Beto for governor in Texas. He is running for governor in Texas. And personally, I'm not a Texan, but I think he would improve the life of Texans wholeheartedly, because Greg Abbott is a piece of garbage.
I agree with that.
But I guess we probably should. I mean, can we do that legally? Like, would it? It's not like I'm preaching from the pulpit, telling people.
No, you can tell people who to vote for.
Okay, so we fully endorse Beto for governor in Texas. Support 100%. I think he would be a great governor. So I know that's one of the high profile races right now. Also, Stacey Abrams in Georgia. Let's go. Let's get Stacey Abrams as the governor.
See, there's a split on the Republican side, right?
No, I did not.
Purdue is running against Kemp.
Purdue is running again? Yep. Really?
Yep.
Okay.
He's got Trump's backing.
Yikes. Like the previous Purdue that was governor, like Sonny Purdue.
Yeah.
I hate to say it, he was not a terrible Republican governor. He was heck better than what Georgia has right now, but who knows now? You know what I mean? Like, who knows now, since he's got the backing of Trump? He could be using Trump. But I think he's central right. I never got the feeling he was Tea Party right. But anyway,
if he has Trump's backing. Yeah,
he will be, unfortunately. But I fully endorse Stacey Abrams, and that is who I voted for in the last governor race, because we lived in Georgia in the last governor race. And that is 100% who I support. Stacey Abrams does amazing work. And it is because of her that so many people got to vote, because she organized buses and transportation and time for those areas that it's hard for them to get to the polls. She organized that stuff, and she does an amazing job. She does amazing work. She is an amazing, amazing woman and just human being. And I think I fully support Stacey Abrams. So we stand Stacey Abrams on this podcast. So if you value our opinion in these kind of things, that's who we would vote for.
Yep.
I was still a Georgia resident, that's who I would vote for. So I think we have one coming up too, but I don't know. I would rather it not be Newsom again, but I don't want a Republican.
Yeah,
But now we're getting into discussions that, are not pertinent to the podcast. Anyway, that concludes our mini series of Roe v. Wade. When we come back, we're going to talk about the Casey one, right? Next week.
KCV Planned Parenthood.
Yes, we're going to do KCV Planned Parenthood next week, and then we will be off for the rest of the year. Have a wonderful week. We love your faces. And I just want to say thank you so much for listening to Learning the Law. If you like this podcast, please don't forget to like, subscribe, follow, and share in all your favorite places. Don't forget to follow us on Twitter at Learning the Law, Ron at Necrokijo, that's Necrokijo, and me at Phoenix Nymphy. If you have any questions, tweet us, comment, DM us, or you can email us at twolazydogsmedia@gmail.com. And we will have Patreon set up at the beginning of next year. I'm very excited for all of the new things coming out. So have a wonderful night. This has been a Two Lazy Dogs production.
Good night, everyone.